me. Adanté, great to see you again. Thank you so much for joining me. I want to start off with that bomb threat. No small thing, serious issue, certainly could affect the mindset of everyone in that courtroom. As of right now, we don't know if something off the record went on where the jury was asked if they were okay or what the effect of that possible bomb threat had on them. I would think you would want something like that on the record, perhaps even asking the jury if they were okay with continuing to sit for this case in light of the bomb threat. I don't know, your thoughts on that?
Yeah, I think it would have everyone on edge, right? Like if you're a jury, you're supposed to be concentrating on the evidence and what's being presented to you. And every time a door opens or there's a loud sound, you're startled, right? Because you don't know if that's the bomb or if that some other part of the threat was called into the court or someone coming down to actually do something. And then I think also what it does, it colors the idea in the juror's mind that this is a serious case, but this is potentially deadly to me. And is the person that we have here that we're standing in judgment of, is he a threat to me personally? So that's a very, very, we would say prejudicial thing to have go on during the course of a trial, frankly.
So how would you deal with that? That's my point. Would it be necessary, at least to get on the record as a defense attorney, this idea that maybe there may be some issue regarding this jury and maybe worrying about their safety in light of what happened?
I certainly, if I'm the defense attorney, I'm pulling out all stops, okay? It's when we say I'd like to preserve the record, Your Honor, or I want to make my record, typically that means we know it's going to go against, the decision is going to go against us, but we're trying to preserve our rights for appeal. So I certainly would be a defense attorney that would raise that and actually ask the judge, at least propose that he poll the jury to make sure that they're ready to proceed and that this isn't going to have an adverse effect on their ability to listen to the evidence.
Yeah, that's certainly what I would have expected. All right, let's talk about this blue raincoat. We saw the cross-examination of the gunshot residue expert today. Your thoughts on that cross-examination? I feel like they did exactly, or the defense did exactly what they wanted to do, suggest that that gunshot residue could have gotten there any number of ways, and she certainly can't tell them when it got on there or how it got on there. We know what the state is trying to get this jury to believe, but again, can they accept her testimony beyond a reasonable doubt after what we heard on cross?
I don't think you can. I think that's the point, right? And I was raising this the other day when we were having this discussion about this blue raincoat and the fact that there's GSR on there. If you can't link it directly to these particular guns, you can't link it to this particular shooting of the shotgun, then yes, you have GSR on there, but you can't link it to this particular crime. And given this has took place out in the country, given that he's been known to have this shotgun and guns in the backseat of his pickup truck and be a hunter, it could have gotten on there in a completely innocent way. And voila, that is the true definition of reasonable doubt. So, I think in some ways, if the prosecution, when they reach to try to add to this mountain of evidence that they're creating, some ways you can reach too far, or some might say a bridge too far.
Now, we heard from two other financial witnesses today as well, and I'm noticing one of the things that the state is doing now with these witnesses, they said in their opening statement that he killed his wife and son to buy himself time and maybe even sympathy. But what I noticed they're doing is they're making sure to ask every witness how they felt about it when they found out what was going on and what the ultimate fallout might be, which I think shows a little bit of a shift in their theory that not only was he wanting to buy time and sympathy, but also he was worried about the overall effect and I think the embarrassment of this whole thing, which to me makes the idea that he made the decision to shoot his wife and son just a tiny bit, not a lot, but a tiny bit more plausible.
Yeah, I think the idea of the fact that the embarrassment, the humiliation, professionally and personally, given he was a man of stature in his community, is certainly something that would weigh on anyone, let alone the murders and the killings that he's accused of. But at the same time, I'm not sure if you're facing that type of scrutiny because of the financial crimes, killing your son and your wife because you're afraid to be humiliated and what that means, to me, it's somewhat of a stretch. However, what it does do by way of bringing in this information and this evidence of the financial crimes, if you're a juror, you're giving this guy the side eye. You don't like him, you don't trust him, you think he's a fraud, and he's willing to steal from his clients. You know, it puts him in a very negative light, which is the very thing that the judge is supposed to be closely watching and safeguarding, which is that you don't convict someone because you don't like them. You convict someone because they were guilty of the crimes charged versus they're just they have bad character. So that's a third rail that I think the defense attorneys will hit on, if not now, but also on appeal.
Yeah, and the judge has given twice already, I believe, that cautionary charge regarding the reason this financial information is being brought in. But it's still human nature. You think about what he did to all these people and vulnerable people as well, that you think of him as a bad and morally corrupt person. All right, Adanté, stand by. I do have to take